पेटगीत. For welcoming the dignitaries with a sapling, we have helping us Zindagi and Sia here. I request Advocate Sharad Bhattad, Vice President, High Court Bar Association, to welcome Vice Chancellor of Nagpur University, Dr. Subhash Chowdhury, with a sapling. Thank you, Advocate Sharad Bhattad, sir. I request Advocate Apurva Kolle, Member HCBA, to welcome today's guest speaker, former Chief Justice of Allahabad High Court, Honorable Guest, Shri Justice Ferdinand Ribello, with a plant sapling. Thank you, Advocate Apurva Kade. I further request Advocate Priyanka Arbat, Member HCBA, to welcome today's guest speaker, former Chief Justice of Bombay High Court, Honorable Shri Justice B.P. Chaudhary Dharmadhikari, sir, with a plant sapling. Thank you, Advocate Priyanka Arbat. I request Architect Subodh Chinchmalakpure to welcome Architect Avinash Pendse, MD of ADR Professional Organization, with a plant sapling. Thank you, Architect Subodh Chinchmalakpure. I request Secretary Institution of Valuers, Shri Surendra Gorde, to welcome Advocate Sharad Bhattad, Vice President, High Court Bar Association, with a plant sapling. Thank you, Valuer Shri Surendra Gorde, sir. I request Arbitrator and Engineer Milan Kade, sir, to welcome Dr. Ravi Shankar Moore, Principal RTMNU, Dr. Babasaheb Ambedkar College of Law, with a plant sapling. Thank you, Milan Kare, sir. I invite Architect Avinash Pendse, MD of ADR Professional Organization, for his introductory remarks.
Hello. I hope I'm audible to everyone. Good morning. Welcome, everybody. Dr. Subhash Chaudhary, Chairman of today's meeting and Vice Chancellor of RTMNU, Nagpur University. Dr. Ribello, our former Chief Justice of Allahabad, Dr. Dharmadhikari, former Chief Justice of Bombay High Court, Advocate Bhattar, Vice President of High Court Bar Association, and Dr. Moore, Principal of Government Law College. I welcome you all, as well as all the august audience who is present here. I'm going to present you about, and introduce you, our organization, which is known as ADR Professional Organization. Few like-minded people from Maharashtra, Goa, and Gujarat, they came together and formed this organization, considering the fact that there are many amendments which are coming in arbitration law. And we realize that there is a potential and also need that exists to have a platform for those people who are from central India, where they can come together, exchange their ideas, and also use this institute for training newcomers in this field. I realized in 2017, similar exercise was done by Indian government to regulate the body of valuers through Ministry of Corporate Affairs. They not only regulated the valuers, but also provided a new, I would say, profession, which is known as resolution profession. And these professionals, they came into existence later with the help of these professionals and valuers. Not only the Ministry of Corporate Affairs regulated industry sector, but also ensured that overall growth of industry as well as business environment. Now, in 2019, they decided to have the similar exercise through Ministry of Law, and by implementing some amendments in arbitration law, which also included not only regulating arbitration and mediation profession, but also regulating and providing education to those who are interested in coming in this profession. As you know, this is of course my feeling, nothing on that our government has a very peculiar habit. I can sum it up in one simple phrase, that is, kahin pe nigahe, kahin pe nishana. And this may be good in foreign policy for the government, but in domestic policy, it did affect it adversely, in the sense that naturally there was a resistance from judiciary. And hence from 2019 till almost now in 24, that amendments could make a very little progress. However, it happened that at least now they have put into, I would say, in the office, they have organized in what they call it as arbitration council. They are appointing a chairman for arbitration council, and under him they will definitely implement many new concepts and new laws that will drastically change practice of arbitration and mediation. However, as I said earlier, though they are talking about regulation of these professionals, in fact, the aim of the government could be something totally different, which has yet to, one has to really fathom it. Anyway, with considering these amendments, we decided at present there are very few institutions in India which can work as an extended arm to government arbitration council under the chairman of provided by the government. So similarly, there are hardly one or two institutes, but there was nothing in central India. So we have provided this platform and expect that majority of those stakeholders, maybe lawyers, maybe arbitrators, maybe even those who are desirous to work as an arbitrator in future, they can come together and take whatever help of this organization. There is also another angle to it. Earlier, most of the arbitrations were in a very simple matter, but new concepts have added dimensions which require many professionals with a divergent background. For example, if I have to say that cyberspace, bandwidth, even concepts like competition, monopoly, even with AI, there is also added angle to arbitration in the sense, I'll give you just one example. Earlier, delay was more, I would say, a concept which arbitrations always dealt with, which was subjective. But today, there are many softwares available which can calculate delay, maybe because of one or the other litigant, and provide not only the percentage, but also the quantification in terms of money for the arbitrator. Now, these things are changing, and definitely there is a need of number of various professionals coming from different background. And considering this, when we formed this institution, we found that our members are coming not only from a legal background, but there are also architects, engineers, lawyers, then chartered accountants, company secretaries, and also we also found one medical professional who said that he would also like to become a member, so he is our member. And they are spread in all these various states. But surprisingly, though the institute was formulated in Nagpur, in reality, we found that majority of members are coming from Gujarat, which is very surprising. Anyway, we started this registered company as a Section 8 company on 10th February 2020. So today we are 4 years old company, and post-COVID, this is our first program, and we intend to continue the similar programs in future with the help of all the faculties which are available here. Taking advantage of this occasion, also a company like AIR, which is a very reputed oldest company all over India in this field, they also come forward and they said they would like to publish one book on arbitration. And I think this will be beneficial not only to various professionals, but also the students in this field. So this is a very short introduction of our organization. I would rather prefer that you should hear both veteran speakers and enjoy. So with this, I thank you all for patiently listening to me and coming here and making today's program one grand success. Thank you. Thank you.
Thank you, Avinash sir, for that briefing. A book has been written on arbitration, and the title of the book is Arbitration Law, A Systematic Approach. This book has been written by Mr. Vaibhav Niti, an advocate of Supreme Court, and has been published by All India Reporter Private Limited. We have with us today Mr. Aditya Vaidya, Chairman of All India Reporter, and Mr. Rahul of All India Reporter. I request them to please come here on the dais and get the book unveiled at the hands of dignitaries. Thank you, dignitaries, for the favors granted. This book, I am sure, is going to act as a lighthouse for those who want to enter into this field. We have today with us Vice Chancellor of Nagpur University, Dr. Shri Subhash Chaudhary, with us as the chairman of this inaugural function. Dr. Subhash Chaudhary has done his graduation in civil engineering, master's in structural engineering. Further, he did his PhD in civil engineering and pursued MBA, PGDIM, PGDOM, and DIM. He has guided 4 PhD students and holds 1 patent in his name. He was in teaching for past 30 plus years and has earlier worked as Pro VC of RTMNU. He had led from front for getting A grade for NAC for Nagpur University. He is a member of various professional organizations and has worked on almost all committees of Nagpur University. Here I present you to Dr. Subhash Chaudhary. Request Dr. Subhash Chaudhary to speak a few words.
Good morning to one and all. Dignitaries on the dais, former Chief Justice of Bombay High Court, Honorable Shri Justice B.P. Dharmadhikari, former Chief Justice of Allahabad High Court, Honorable Shri Justice Ferdinand Rebello, Principal of this college, Dr. Ravi Shankar Moore, Advocate Sharath Bhattad, Vice President, High Court Bar Association, Architect Avinash Pense, MD of ADR Professional Organization, the dignitaries and all stalwarts from the judiciary and law sitting in this hall, and the participants for this symposium, and dear students. On behalf of Nagpur University, I welcome you all. And not only this situation of regular, but I would specifically mention that we are sitting and this symposium is being conducted in the institution of university which has completed 100 years. And this is the centenary year of the university. And I can proudly say that this university has developed so many stalwarts in the judiciary, and it has a long history. Narasimha Rao was also the student of this university. So there are so many alumni which we can list out, and definitely we will have one complete history of 100 years of the university. Now coming to this symposium, this arbitration and mediation, really it is a good tool or way to resolve the issues. I am not the person from the field of law or judiciary. That's why I would not say much more on this, because the stalwarts of this field are here, and I am very beginners, or I can say I am nil in this field, but I can only put some views on this symposium. You see, Nagpur University has started to extend its services to the areas which are far away. And that's why when the centenary year was started, we launched one slogan, that is reaching to unreached. And we started to reach to unreached people. I personally visit so many villages, and I had many visits also. I have seen the scenario there. Not only to visit, but university has taken the social responsibility to develop the interior areas or remote areas or village areas in the socio-economic development, for the socio-economic development. We have started with the medical awareness, integrated farming, skill development, starting of the production unit in the form of clusters. So many things we have started. We have one concept of this extension of law services to remote areas also. And what are we doing? Because I feel that the institutions must be utilized for the development of nation, which is still idle. Most of the time it is said that the manpower is very less to implement or execute any policy or any decision. But I think we have so young manpower in all universities, and they are working idle. They are keeping idle. Our education system was like that. But since last year, we have made one policy that whatever may be the department, whether it is physics, whether it is chemistry, whether it is sociology, archaeological department, tourism, whatever it may be, mass communication, we are using each department to go to the villages to find out this problem and to resolve the issues. So, in Nagpur University itself, there are more than 4 lakh students. What are they doing? They are sitting simply within 4 walls and studying and getting degree. But experiential learning is the concept where the students need very much. The time has gone that the degree played a much more role. But now the skill, its confidence and experience or experiential learning is more important. And that's why we are using the students of department to start from lab to land. Similarly, we can have this. I request all the dignitaries in the field of this judiciary. Can we make such policy at the state level or national level? Because at university level we have made it. Because we have identified many more things. In rural areas there are so many legal problems. And the village people doesn't want to come up for any litigation to put any complaint. And they are facing many problems. Their mutual dispute may be resolved by their own, but there are another problem. Dispute between bank and farmer, dispute between Tehsil office and farmer. Government agencies, they put them in the very wrong way or they take some decision which is really against them. But they never come forward to shout only if anyone wants that he has been victimized, then anyhow he approaches to court, Tehsil office, SDOs and all that, but at last he failed. But can there be a mediation only in between government offices and the public, common public, farmers, workers, which are not in position to demand for justice? Because now for justice, one has to pay fees and the common people is not in position, especially from rural areas. So we started, and only law department we have not touched, but this is our policy, that whenever student goes or student visit for any area has been allotted, that this team has to go there, this team has to go there. All those, and those problems will be given with their related field, with their related departments, with their related subject. And they will be given experiential learning through these case studies, or resolving the issues, or designing the system, or developing the technology. And the university issues the credit certificate, and that is the internship. Because now it is compulsory that every student must undertake the internship. So can we add internship? These students can be utilized. Lot of you imagine every village will have some mediator, and student of final year can act as mediator. Student can get the experiential learning. They can have some experience. They can resolve those disputes, and within the villages, resolving issues or disputes will not require any intervention from the government. But dispute between the government agency and the common public, it has to somewhere regulate or add some value, so that whatever the crunch of manpower can be resolved, institutions can be used for the development of nation. And definitely, all colleges, all universities are having number of youth which can be utilized. Lakhs of students are there which can be utilized for this very developing purpose. And I think all these dignitaries may have understood my spirit of this deliberations. And I think university has started, and definitely our student will go to the remote places and will try to resolve the issues, and they will get the learning from them. They will have the direct learning experience through the case studies and all this through the practices. And I once again welcome you all for this symposium, and I hope the all participants will get benefited through today's deliberations, because the judiciary, or we can say the justice of a high level, are here to address you, and definitely it would be helpful for every one of you. And with this note, I conclude here. Thank you very much.
Thank you, sir. 4 lakh students, 100 years of age, starting so many new schemes in Nagpur University. That is a great statistics. Wishing Nagpur University all the very best. We are almost towards the concluding of the inaugural session. And on special request, Vice Chancellor and Chairman of this function, Dr. Shri Subhash Chaudhary has graciously accepted the invitation to be the Chairman of the inaugural function. He has certain meetings lined up. On behalf of ADR professional organizations, the High Court Bar Association, RTMNU's Dr. Babasaheb Ambedkar Law College, and on behalf of the August House, I thank him for his valuable time and request Dr. Moore and Engineer Sanjay Kaya to escort him from the dais. Please be seated, dear students and all the dignitaries. Attending seminar or symposium, in my opinion, is like reading multiple books. That too in half-day session, which otherwise is impossible for an individual. But the experts who have lived their life for this specific topic, when present things in front of us, we get best of all books. If you have seen Formula 1 F1 race on TV, the average speed of the car is about 350 kilometers plus. And at such higher speeds, if you flicker an eyelid and you will miss great actions. So strap up your seat belt, be attentive, and here we are, ready to zoom into the first session. And yes, again, that gentle reminder, please keep your cell phone switched off, or there is going to be a penalty here. Beginning with the first session of the symposium, Mediation, Present and Future. This session will be conducted by our guest speaker, Honorable Sri Justice B.P. Dharmadhikari sir. And to introduce him, I invite advocate and expert in cyber security, Mahendra Limay sir.
Good morning, everyone. I have occasion, or this is my privilege to introduce with you none less than Justice Bhushan Dharmadhikari sir, who has been Chief Justice of Bombay High Court and student of this very institution. Young students may not be knowing this. So, Shri Bhushan Pradyumna Dharmadhikari is born on 28th April 1958 and educated in BSc Biology, additional BA English Literature, LLB. He obtained BSc degree in summer 1977 and law degree in March-April 1980 from, as I told you, this prestigious institute. He practiced law at Nagpur since October 1980, and after his enrollment with Bar Council of Maharashtra, after obtaining LLB, he joined Chambers of Advocate Y.S. Dharmadhikari at Jabalpur for a brief period and then came back to Nagpur and worked under Advocate H.S. Ghare till 1984. He started independently after Shri Ghare became city civil judge. He appeared for several government corporations, industries, employees, unions, and private clients in all courts like labor courts, industrial courts. Then he was elevated. He briefly held the post of Secretary of Bar Association for 4 years and unopposed library in charge, High Court Bar Association for 3 years. He was elected Treasurer HCBA for subsequently 3 years. He has been guest lecturer at judicial and other training institutes in Nagpur since last 25 years. He was elevated as additional judge on 15th March 2004, as judge on 12 March 2006. He has also officiated as director of Maharashtra State Judicial Officers Academy. So, he was superannuated as Chief Justice of Bombay High Court on 27th April 2020. After his retirement as Chief Justice, he is designated as Senior Counsel and actively engaged in various mediation and arbitration activities. So, with this much introduction, I request Justice B.P. Dharmadhikari sir to start his session.
Before that, a small pleasantry, sir. Thank you, Mahendra Limay, sir. I request Vice President, High Court Bar Association, Shri Bhattad, sir, and Shri Milan Kale, sir, to felicitate our guest speaker, Honorable Shri Justice B.P. Dharmadhikari, sir, with a memento and a souvenir to be presented as a token of love and appreciation. Thank you, Sharad Bhattad, sir, and Milan Kale, sir. Honorable Shri Justice B.P. Dharmadhikari, sir, the floor is yours now.
A very good afternoon to all of you. I have got two of my seniors here, not only in profession but also as Honorable Judges of Bombay High Court. First is the guest speaker, Honorable Justice Rebello, who retired as Chief Justice of Allahabad High Court and elevated little later but still was senior to me, Justice V.C. Daga. Honorable Justice Rebello retired in 2011 and Honorable Justice Daga retired in 2012. I have learnt a lot from both of them. And it is good that by some accident or I do not know what it is, I have been called upon to address this august gathering before Justice Rebello. Otherwise I was shown after him and it would not have been proper in protocol. So accidentally what has happened is in accordance with protocol. So with this, I will begin with today's subject. Honorable Justice Rebello, Honorable Justice Daga, Shri Pense, Shri Bhattad, our principal Shri Morris, out for some other work, other honorable dignitaries, Shri Aditya Vaidya and Rahul Pandit, who represent All India Reporter here. As you are already told, I am the student of this college. And when I took admission, it was Section D, LLB first year Section D, and our classes used to be conducted in this hall only. So my association with this hall goes back to 1977-78. And on few occasions thereafter, I have come to this hall, and this is one more occasion and a pleasant occasion to address you all in this gathering. It is also very heartening to note that this is 100th year of the Nagpur University. I've been associated with various law institutes, universities, and what I find is the universities like Nagpur University or its law colleges like this one, they are not getting necessary patronage and necessary attention is not being paid. So that is the aspect which should bother all of us, and something needs to be done about it. Now, my friends, coming to today's subject, I will deal very briefly why this alternate dispute resolution has become necessary. When you think of obtaining a justice through court, a very large infrastructure is required. Court building, judicial officers, other staff, and all this then requires lot of space also. Now this space has become a constraint in almost all cities, all towns. Expansion of courts cannot be a solution to this. And courts do not generate any revenue for state government. So generally state governments are not willing to spare funds for court development. Though funds are given, ample funds are made available, still the courts do not get the land, and there are several other problems. Now coupled with this, all this infrastructure is used only for 8 hours or 9 hours in a day, not more than that. Many of you know that shift working was tried, but it could not succeed for various reasons. Now, in this backdrop, if you look at pending cases, about 47% of total pending cases are more than 3 years old. And only 25% are about 1 year old. So, period taken for adjudication is also huge. After one adjudication, the controversy does not end. It goes to second court, it goes to third court. Many times matters go right up to Honorable Apex Court. In lighter vein, therefore, it is always said that whatever may be the decision, it is always green pastures for advocates. Because every decision gives rise to a new case. And if this is the position, you will find that many big clients, big houses, they are not inclined to file court case. They want to somehow resolve the issue and get over it to proceed further so that they can progress further. Now, so far as Maharashtra is concerned, I have got the statistics here, I will not go into details, but about 86% cases could be disposed of in 2023, 94% in 2022, 92% in 2021, and about 65% in 2020, which was a COVID year. But then, new cases are added. Not only that, in many cases there are remands, matter come back. So, if anybody asks me, average life of any litigation in any court is about 3 years. So 3 years in trial court, more than 3 years in high court, and then equal period perhaps before Honorable Apex Court. So 7 years, if you go to court, the resolution of issue normally takes. Now, total pendency in Maharashtra is about 51,60,471 cases. And on an average day, about 1,12,347 cases are listed before the courts. So 1,12,347 cases, about 25 working days in a month. 51 lakh cases, if they are listed once before the court, it will take about 2 months. So you will not get next date before 2 months normally. Now all this therefore is not found very encouraging by business people. Even a normal man does not find this proper. He is also interested in getting solution to his problem either way because he wants to proceed further. And added to all this is again one more factor, it is uncertainty. What will happen in court? Now, I remember way back when I joined practice in 1980, I handled a matter. The question was whether a particular person was a workman and a particular department of state government was an industry. From 1956 till 1979, when Bangalore water supply decision came, you get views either way. Then Bangalore water supply says that yes, government department is industry. This goes on till 2005, when in state of UP versus Jasbir Singh, the Honorable Apex Court feels that matter should still be placed before a larger bench for reconsideration. Now this is one aspect, whether it is department is industry or not. On workmen also, same thing goes on. And therefore, if I advise somebody, this is the position, this Benami Transactions Act is going to hit you, some years thereafter a judgment comes, it says, no, that was not the correct view, and now this is the position. And then the client comes to you, sir, I settled the matter, but now this is the position, what can I do? So these uncertainties about the outcome, uncertainty about the time taken, all this prompted people to think of what should be the way out. And ultimately, the alternate dispute resolution solutions were developed by people through law, and Section 89 was introduced. Now, we need not go into all that history, but in 2005, the Honorable Apex Court has then found that this duty to refer the matter to ADR or to mediator, the court cannot shirk, court must refer the matter. In that judgment, there was one more important observation by Honorable Apex Court. The Honorable Apex Court says that central government has to arrange for and provide necessary funds to courts for delivery of speedy and effective justice. And in very same judgment, Honorable Apex Court then suggested examination of the impact which various laws put on court. You are all aware when this check dishonor provision, Section 138 of Negotiable Instruments Act was enacted, there was lot many matters. Courts were flooded, and in one court at Bangalore, a complainant came, he wanted to file 1,29,000 complaints on same day. The Honorable Apex Court in this scenario says that judicial impact assessment should also be done. There are many legislations which say that special courts are created. But on ground you will find that there are no special courts. Additional charge is given to existing court, and that court which is already flooded with matters gets further more matters. A common man feels that when there is an additional or special court, why my case is not being taken up? The other important judgment which has come is in High Court of Madras versus MC Subramaniam 2021 judgment of Honorable Apex Court. There the question was, if it is a private settlement, whether benefit of refund of court fees, which has a provision which has been enacted in Court Fees and Suits Valuation Act, is available to such private settlements. Madras High Court took a view that it must be liberally interpreted. All settlements, whether reached privately or otherwise, need to be honored, and court fee needed to be refunded. The matter goes to Honorable Apex Court. Honorable Apex Court upholds that view, and the Honorable Apex Court observes that losing one-time revenue in such matters should not be the consideration for either state government or the registry of the High Court. Now, what is happening in mediation? I tried to find out, and most of the matters, about 66% of the matters were settled at Bengaluru Mediation Center. Matters, 80% of the matters referred to that center were found worth settlement. And out of them, 66% could be settled. So 77,839 matters were taken up for settlement, and 40,854 matters could be settled. Now, if this is the position, if mediation puts an end to a problem once for all, speedily, I will deal with 2023 Act little later, but still I am saying speedily. Why should not litigants approach to mediation? Now, there is slight difference between mediation and arbitration. Arbitration and court proceedings are, I may say, similar, because they have got an element of dictate or mandate from some third agency. Court orders, passes decree which needs to be obeyed. After the award is delivered by arbitrator, again, it may be as per your liking, it may not be as per your liking, but you have to obey it. Subject, of course, to challenges which are open. But in mediation, unless you agree, mediation cannot succeed. Now, if this is the position, the litigants and lawyers have to look into it and find out whether to accept some decision by some third agency, or then to accept a mutually agreeable solution once for all. Now, you have all seen Specific Relief Act was amended, a section was added, rather proviso was added, that in matters of public work, public importance, no injunction, no stay will be granted. Interim stays given by courts shall not operate more than 6 months. And then in 2024 also some amendments have been suggested which are being looked into. This scenario therefore shows need for ushering one principle. Accountability is the aspect, but I will call that principle collective responsibility. If we can do it, because I came across one Delhi judgment where the Honorable Judge observes that false cases were being filed by government and false pleas were being raised by government. Then the judge therefore suggests some mechanism, some policy for its incorporation in new national litigation policy. In 2014, there was one judgment by Honorable Apex Court, State of Gujarat versus Kishanbai. And there, I will read only the very brief portion from paragraph 23. A finding needs to be recorded in each case whether the lapse was innocent or blameworthy. Lapse in criminal investigation. We also feel compelled to require the adoption of some indispensable measures which may reduce the malady suffered by parties on both sides of criminal litigation. Accordingly, we direct Home Department of every state government to formulate a procedure for taking action against these guilty officers who commit such lapses during investigation and to complete that action within 6 months. The Honorable Apex Court in this judgment says that every acquittal brings on record persecution of innocent man. And for this persecution, if some blame is to be put, if it can be cast, the guilty officer, investigating officer, must be punished. Now, this principle, according to me, therefore, must be even extended on civil side when civil cases are tried by courts. This must be looked into. Because when evidence is being laid, when advocates assist the court, matters are argued, inquiry whether this litigation is bona fide or it is outcome of some malice, it was only a delaying practice, or an abuse of process of court can be easily recorded. And if that finding is recorded and further action is directed, perhaps these cases which are being continued, now the chart with me shows that there are some cases which are pending for more than 40 years. So these cases which are pending, those cases can be taken care of. Provisions of CPC can definitely be amended to add this provision, making it mandatory for courts to record findings on these aspects so that the litigants who want to take advantage of their money, their position in society are controlled or put to some check. One more mechanism which can be introduced is a system of obtaining advance ruling. On taxation side it is there, but when there are big litigants, both companies or stakes are high, it can be made mandatory that you first obtain an advance ruling from some independent advocate, independent authority, and that can be done by some independent agency. I think this 2023 Act, the Mediation Council of India, MCA, which is formed, that can look into such advance ruling aspect, and if such grievance is made, it can also record finding and give the advance ruling. Very recently, my friends, and it is all of us know, Economic Times had reported that India is said to become $1 trillion economy and it is likely to surpass USD 4 trillion in 2024-25 and further escalate to USD 5 trillion by 2026-27. This is according to PhD Chamber of Commerce and Industry. Then there is also some observation. Industry Chamber also expects the RBI to cut the repo rate by 100 basic points in calibrated manner by the end of year 2024. Now, all this therefore shows that funds are being made available by the government, and as we are seeing, infrastructure is also being strengthened. A young businessman, he cannot wait. He has to keep pace with times. And if you ask him to wait for 6 years, 7 years, or indefinitely, and that too without any certainty, perhaps his life will be spoiled. So this is again a zone of concern which requires some statutory modifications. Now this MCI no doubt speaks of statutory mediations, but what I feel is, in most of the litigations which are pending, it is either government or some public body, I will loosely say public authority under Article 12 of Constitution of India, which is one of the parties. Relief is sought against it. Now, if in the enactment under which this statutory body is formed, if we speak of a municipal corporation, Maharashtra Municipal Corporation Act, if we speak of municipal council, Maharashtra Municipalities Act, or then Companies Act, Cooperative Societies Act, if these acts are amended and a provision is made that unless and until there is first an effort to mediation and a certificate from mediator that mediation has failed, the matter will not be entertained. Now, many of you know there is a provision, Section 18 CPC. Before filing a suit, you are required to give a notice to state government, central government, or other similar authorities. Wait for a period of 2 months. After expiry of that period only, you can file a suit. This period of 2 months is given to them with some purpose. They have to consider what is their position about the grievance made in legal notice. The Parliament perhaps then felt that in genuine cases, the grievance will be redressed. So it was, Section 80 notice was ventilation of grievance, and with hope that it will not go to court. But now Section 80 notice, everybody knows, has become only an empty formality. There are many other laws which prescribe similar notices, make it mandatory. In this fashion only, I feel that there can be a provision for mediation. Mediation can be compelled. So if you are giving suit notice for 2 months, in the meanwhile you go to mediator also within that 2 months, 3 months, because under new act it is 120 days maximum. So within that period you get the decision from mediator. If that is compelled, perhaps the backlog will be curtailed slowly in judiciary and mediation will succeed. Now this therefore reminds me of my old idea. I could succeed only in one matter. Bring your problem, your law, and take solution within 7 days. So if you have got a problem and both of you agree that this will be our mediator, you can go to him with your problem. You can explain to him the facts, you can explain to him the law, and you can get the decision from him within 7 days. And there are many competent lawyers, honorable retired judges in city who can easily do it within 7 days, provided the litigants are willing. And this can be mandated through a statute. And if slowly the people become accustomed to it, I feel that people may not go to court in such huge number. Now, with this, I will come to 2023 Act. This is not a forum where I can deal with it in detail. But like Section 7 of Arbitration Agreement, there is a provision for mediation agreement also. So, in a contract, parties can agree to have a mediation. There is also a provision for pre-litigation mediation, which I talked of. Before filing litigation during suit, during notice period, you can have a pre-litigation mediation. Then there are certain exceptions that these are the matters which are not fit for mediation. So we need not go into those exceptions. Power of court to refer parties to mediation. Then what should be place of mediation, procedure for mediation, when the mediation commences, how it is to be conducted, what is the role of mediator. Important provision is the time limit of 120 days has been prescribed for finishing that mediation. Extension is possible in exceptional cases. Exception is only of 60 days. This agreement, after it is reached, it can be registered also. Then on what grounds it can be challenged, etc. it is there. Then there is also a provision for institutional mediation under the Act. And for that they have prescribed Mediation Council of India. One of the learned speakers said that what is the object of government in prescribing or providing for registration, etc. of the arbitrators or mediators. Now, so far as this mediation aspect is concerned, I see that ordinary men, not only advocates, but also non-advocates, who have expertise in other fields in life, they may also mediate in such disputes. Many people have got that capacity. I will call it a property. So that property they can use for mediation. But if anybody is going to use his position, his intelligence, his power to mediate between a dispute to which he is not a party, he may learn many things. And also there may be allegations and counter-allegations depending upon the stakes. It will develop definitely as a profession. What I see is, today we see in every lane, on every road, the huge boards with names of advocates, Advocate Supreme Court, Advocate High Court. We'll see names of Mr. So-and-so mediator, Mr. So-and-so or Mrs. So-and-so, Miss So-and-so mediator. And this will become a practice. Now, if this is going to become a practice, these learned members who will be practicing this profession, they will be required to be subjected to some supervision. It will be a profession. So, like we have got a concept of professional misconduct. In all fields it is there, right from architects, chartered accountants, engineers, doctors, advocates. Same type of discipline will perhaps be evolved and everybody will be subjected to it. That is perhaps the object. The learned VC said that students are being deputed and injustice or wrong practices are being located and are being dealt with. The courts have got a scheme, Nyaya Apale Dwari. A mobile court is provided. That court goes to remote areas and tries to resolve the problem. Not only this, but camps are also conducted by courts. Honorable judges go to remote areas where camps are organized. The villagers come there and their problems are looked into. There is also one more mechanism, that is public interest litigation. If something gross, something very serious is brought to notice of court, suo motu cognizance is taken, the concerned party who has brought it to notice of court need not appear, court appoints some able advocate as amicus to assist it, and the problem is attempted to be solved. Now here I remember one thing, we conducted a camp at some place, and there Sarpanch, Police Patil, Talatis, all such people who operate at village level, they were present. Everything was explained to them. Our idea was to explain and to give publicity to various government schemes. That time there were about 101 government schemes which were not known to people, not known to many people. And simultaneously with this litigation-free village, Tanta Mukta Gaon, that was also going on. One Sarpanch, then we got a complaint. She was moving thereafter in all villages, stating that she has been now authorized, and she was forcing people to withdraw their court cases because your village is to be made Tanta Mukta. So that is how it happens. But then these schemes are going on since last more than 10 years. And in first few such camps, the courts also encountered opposition from bureaucracy, from elected representatives. They were against the idea. They felt that courts are going to take their credit. We are required to ask them to associate with us. And that is how it started working. And now everybody is aware of these schemes. With this, my friends, as I told you, I see a bright future for mediation. Many of you may not be practicing as advocates, you may be practicing as mediators in future. So, with this I will conclude. Thank you very much. I also thank organizers for giving me this opportunity.
Thank you, Honorable Shri Justice B.P. Dharmadikari, sir. For those of you who have got their plan sanctioned from the local sanctioning authorities, NMC and NIT, you must have realized it takes a lot of time for those plans to be sanctioned. Now, government has come out with a scheme in which architects and professionals are allowed to sanction these plans, but there is a resistance on both sides. Eventually, this might fade away. Subsequently, as told by Dharmadikari, sir, if retired judges, honorable judges, if they act as resolution professionals, lot of disputes could be settled well in time and to the advantage of the society. That I feel would be a great help to the society as well. Well, I recognize the presence of Honorable Judge V.C. Daga, sir, in this house. I recognize your presence, sir, here in the house. The second session in this symposium is arbitration, present and future. This session will be conducted by our guest speaker, Honorable Shri Justice Ferdinand Rebello. And to introduce him, I invite Vice President, High Court Bar Association, Advocate Sharad Bhattad, sir, to the dais.
Good afternoon, everyone. My Lord Justice Dr. Rebello, former Chief Justice, Allahabad High Court. My Lord Justice B.P. Dharmadikari, former Chief Justice, Bombay High Court. Dr. Ravi Shankar Moore, Principal, Dr. B.R. Ambedkar College of Law. Dr. Avinash Pense, MD, ADR Professional Organization. Members of High Court Bar Association, AIR, DLSA, dignitaries of the dais, faculty members of law, students present. I have the privilege of introducing Justice Rebello. My Lord has numerous achievements in his long career, not only in field of law, but also in field of education, sports, including cricket and hockey. My Lord was born on 31st of July 1949. He completed his graduation in BSc and then obtained degree of law and was enrolled as a member of bar on 30th July, just a day before his 24th birthday. And he has been conferred with doctorate by Mumbai University in May 2015. He has a keen interest in teaching and was a lecturer at Salgaonkar Law College, Goa from 1975 to 77. My Lord was also elected as a member of Legislative Assembly of Goa, Daman and Diu in 1977. He maintained relationship with legal fraternity at Goa, and from 1994 to 96, he was elected as President of Goa Bar Association. Bombay High Court, looking to his legal acumen, has designated him as Senior Advocate in December 1995. My Lord was appointed as Judge of Bombay High Court on 15th April 1996, and he served as a Judge of Bombay High Court till 25th June 2010. He took oath as Chief Justice of Allahabad High Court on 26th June 2010. During his justice as a Judge of Bombay High Court, my Lord has visited Nagpur bench also for a couple of times. My Lord is now actively involved in arbitration proceedings and legal consultation. As an arbitrator, he conducted domestic and international arbitration and has also conducted over 140 arbitral matters. He is also presiding arbitrator in international arbitration, has been examined as expert witness in international arbitration in Singapore, and has also given expert opinion in several international arbitrations. As a part of official delegation from Bombay High Court to conduct study on mediation system in the United States of America with a view to implement similar process in India, he represented Bombay High Court. He is an advocate and a judge, and he as an advocate and judge has contributed various articles on law. He presided and participated in several workshops, seminars and conferences in law and correlated subjects, and he is also an advisory committee member of International Arbitration and advisory council member of Law Academy at Mumbai University. Sir, as a member of High Court Bar Association, which has a legacy of having its members adorn top posts in judicial in state as well as in India, it is in its centenary celebration are delighted to have your consent for accepting the request and addressing the topic of this event. We welcome my Lord at this event and are eager to hear from my Lord. Thank you.
Thank you, Advocate Sharad Bhattad, sir. I request Advocate Vishwajit Singh Oberoi, Library in Charge, High Court Bar Association, and Engineer Avinash Bhatt, sir, Director, ADR Professional Organization, to felicitate our guest speaker, Honorable Shri Justice Fernido Rebello, with a memento and a souvenir as a token of love and appreciation. Honorable Chief Justice Rebello, sir, the floor is yours.
My colleagues, Justice Dharmadhikari, Justice Naga, other dignitaries on the dais, Mr. Avinash Pense, Mr. Sharad and Mr. Moore, the principal of the college. I am indeed privileged to have accepted this presence today, thanks to Avinash, who is working with me on a committee for the Mumbai Port Trust. And all the more important to be in this institution, which is named after one of the greatest sons of India, Dr. Babasaheb Ambedkar. Now, many of you will say Dr. Babasaheb Ambedkar was the pioneer, was the man who gave us our constitution. Yes, that is so. But what is more important is he gave a direction to his community and to others that put in an effort and you can reach the skies. So this is a great, what you may say, a thought process to all of us that disabilities, where you come from, your social strata, are irrelevant. What is important is the drive, the purpose, and you can achieve it. Having said so, as a judge of the Bombay High Court, I come from Goa. And I was sitting on bail applications for all of you from Maharashtra who are present over here. And practically every day I was getting applications in case of dowry death. Now Maharashtra is a land of great social reformers. And I asked the lawyer appearing before me, and I can name him because afterwards he became one of my colleagues, and he was then the president of the Bar Association, Justice Bhosle, what is happening? Because to me in Goa, we had never heard of this concept of wife burning. He says, I will not appear in this matter. I said, point is not that you will not appear in this matter. The point is, in spite of your great traditions, why must this continue? Well, laws can't help that. It is social transformation alone which can help that. It's a thought process which can help that. Now, having said so, I now concentrate on the issue before us, the subject for today. Now, arbitration, like any other law, evolves based on the social and economic stages in a society. Arbitration has evolved without government interference. Arbitration has been involved by merchants trading across the globe. It is not something new. It goes back to 5,000 years. It goes back to our own civilizations. We have the Pancha system. We have the Sareni system and other forms of system where people decided small dispute. And I was doing a research. I was asked as to why were they succeeding? And the answer was simple. You go to a village and you have a panchas deciding disputes in the village. They know both parties. And before your own peers, you can't lie. Because they know what is the position. And therefore, things were succeeding. Of course, now, the punch system also had its a side, namely, it was more caste-oriented than the others. And then economic factors, other factors have resulted in transforming all these matters before courts of law. Now, what is arbitration? Arbitration basically is two persons having a dispute going before a third person, or two other persons who appoint a third person and getting the dispute resolved. This basically is the concept of arbitration. Now, in the course of my speech, of talk today, and I will not be too long, considering I know there are too many students over here, and most students like to hear two lectures at the same time, without a break. So I will bear that in mind. So the issue before us now is arbitration an answer as an effective ADR, an alternative dispute resolution? Now you come to Bombay, you have the Mumbai Stock Exchange. Now for over 100 years, disputes arising between members of the Bombay Stock Exchange don't go to courts. They had their own internal system. And who decided that? It was decided by their own members who are experts in the field, who did it. So therefore, arbitration requires an expertise in the field. Without expertise, it will not be possible. And when you say expertise, for example, we come to as judges. What should be your expertise in the field? Writ jurisdiction is one. But you must have your solid knowledge of contract law. You must have your solid knowledge of other commercial laws. Now, without having this basic knowledge, either as an arbitrator or as a judge, it becomes difficult to decide on those subjects. Now, in the course of my speech, I will be commenting on some judgments, and the law students may note that my comments are not Article 141 comments. You will still be bound by the judgment of the Supreme Court, that will be the law. But I will point out to you in the course. Now, right in the beginning, arbitration in India is not something new. It was there in the old code of, before the 1908 code came into force, it was there in that part of the Civil Procedure Code. Then came the Act of 1899. Then we have the 1940 Act and the Act of 1996. This is the history of the arbitration acts in India. But believe me, every time an act came, our judges always said, "Oh, what have they done? There are too many open questions left." Now, one must understand that when the draftsman drafts a law, he takes into account the social and political norms of those days. He can't foresee for the next 50 years. He may foresee for the next 10 years. He may foresee what is happening in the world around and then put that into the act. But then, human minds are such, lawyers are such, that you always pick up some fault somewhere. And if a judge does not have his basics right in the subject, then he commits mistakes. Now, in the Act of 1899, comments were made, and the judgment is on Dinkar, for those who are academically inclined, Dinkarai Lakshmi Prasad versus Yashwant Rao Mani Prasad, AR 1930, Bomb 98. Under the 40 Act, you will remember the famous comments. Lawyers laugh all the way to the bank and philosophers weep. This is in Guru Nanak's case. And then came in the 1996 case, where in Bhatia International, the Supreme Court lamented. But nobody laments when judges go wrong. And I'll point out to you where judges have gone wrong. And it takes 10 years, 15 years to remedy those mistakes. And in the course of that, more mistakes are committed. And still after the mistakes are committed, you continue to make further mistakes. Now, the first aspect of why arbitration, you may ask, why should a person go to arbitration? Now, between the court of law and an arbitration, both decide the same issues, namely, the subject matter which can be decided by a civil court can also be decided by the arbitrator. But here the Supreme Court says no, so there are some as to whether the arbitrators can fully decide what the court can do. I'll come when it comes to fraud. So therefore, there is the subject matter, what the court can decide, the arbitrator can decide. But what is important is, arbitral process is faster. Arbitral process, you can choose an arbitrator of your choice. You can decide whether this person is competent enough to decide my issue, unlike the courts where in the court of law you'll go to a judge. Now whether he has the capacity for it or not is immaterial because he's supposed to know all the law. But in arbitration we can decide, well, look at the profile of that man. Will he be in a position to handle my matter? And then go to him. Third and important, in matters of commerce, you have situations where people would not like their trade secrets to be known to others. In a court of law, they are open, known to everybody. But in an arbitration, it's behind closed doors, others are not available. So your trade secrets, just a glass of water. Water. So they are kept secret, they are not open to the public at large. You may say there is a disadvantage, and what is the disadvantage? The sole disadvantage may be the cost factor insofar as the fees of the arbitrator are concerned, not the fees of the lawyers. But there are, at the same time, there are no court fees payable. So practically it balances out between the two factors, less hearings. So therefore arbitration as a means, as an ADR to settle disputes is much better than going to ordinary courts of law. I am not speaking about mediation, my brother has spoken about that. Now, having said that, what is the first step in the arbitral process? Now, some of you are lawyers who may be appearing in the matter, some may be drafting the matter. So what do you do when you start and when you look at a contract and try to draw the arbitration clause? The first important aspect that you have to bear in mind while drafting the arbitration clause is the scope of the clause. What can be referred to? The second aspect which you have to bear in mind is what will be the substantive law of the arbitration? Will it be Indian law? In international arbitration, though you are situated in India, they may say it is the law of England or somewhere else, which is applicable. And the third important point is the seat of arbitration. Because the seat of arbitration determines what will be the arbitral procedure of the arbitration. So these are the important facets in the arbitral process. Now, many a time lawyers, draftsmen, while drafting these laws, don't put into it, and issues arise. In an international arbitration in Sul America versus Ineza, it was an insurance contract drawn up in Brazil. The law was supposed to be in England. The seat of arbitration was not provided for. But as the seat of arbitration was in England, a test was evolved, apply the seat of arbitration where the persons are sitting, and that would be the applicable procedural law for arbitration. So that should not be left open for a chance. That must be provided in the contract itself at the threshold. So eliminate all chances. Now, modern day arbitration clauses also provide for pre-conference arbitration. Now, pre-conference negotiations before you invoke the arbitral clause. Now, why is that required? That is a form of, I would say, mediation or other forms whereby parties can come together, apply their mind, and see if there is a possibility of a settlement. So it is given, sometimes it is worded differently. It is called negotiations. It is called mediation. It is called conciliation. Now, when the matter comes before the tribunal, one of the points I immediately argued would be, if you don't have a recourse to this principle, that this has been bypassed and therefore the tribunal has no jurisdiction. Now, various issues fall out of this. The first issue is, if the parties have not negotiated, Can such a negotiation be specifically enforced? Ultimately, the answer is no, you can't, because there is no determination. If parties don't go to mediation, can that be resolved? Can that be a ground for saying you have come prematurely to arbitration? Again, the answer is no, because mediation is something that cannot be specifically enforced. But if it is conciliation, yes, because conciliation results in an award. Therefore, one has to be practical in providing these clauses as to how you balance between your clause in the arbitration. Then the third aspect is what disputes can be referred to arbitration. Now, this is very important. And we have a whole line of judgments starting with the State of Goa versus Praveen Enterprises. And let me frankly tell you that development of arbitral law, Justice Ravindran has been one consistent judge in a long line of judgments who has balanced the law of arbitration in India till it was undone in some other matters. And after him, of course, has come Justice Nariman, who had also his solid grounding in the law of contracts. So therefore, I had come back to this. In Praveen Enterprises, Justice Ravindran says that what can be decided is depending upon the scope of the arbitral clause. If the arbitral clause says all disputes, then all disputes can be decided. If the arbitral clause says only matters which are referred to arbitration, then in only those matters can be referred to arbitration. An incidental question arose whether a counterclaim could be filed. Of course, now Section 23 has been amended, which specifically provides for a counterclaim. Those days there was an issue whether a counterclaim could be filed at all. So these are areas which one must bear in mind while drafting the arbitral clause, because the whole amount of issues will arise in this matter. Then after invoking the arbitral clause, the next step is choosing your arbitrator, which I have discussed earlier. So it is important how you select your arbitrator. A man of your... Now many parties believe wrongly that because I nominate this arbitrator, he has to decide in my favor. That is not a job of an arbitrator. You have nominated him to do justice. Fine, in the areas of interest, in the areas of cost, an arbitrator may try to balance the factors. But I, as a judge, who have been sitting down dispensing justice, supposed to be impartially, how can I, because you have nominated me, turn around and say, no, because you have nominated me, I will take your point of view? No, that can't be. So therefore, it is important that you choose your arbitrator carefully and wisely. There are some who take a long time to decide, so that is also the background, whether this arbitrator can dispose of the matter expeditiously or not. Then comes the most important part in arbitration, the dispute resolution process. Now, when there's a clause in the arbitration, if both parties agree to the appointment of an arbitrator, then the arbitrator has full jurisdiction to decide all issues. Now, the Arbitration and Conciliation Act of 1996, under Section 16 of the Act, has brought in the concept of competence, and severability. What are these doctrines? The first doctrine is that a tribunal has jurisdiction to decide all issues which may arise. This could be an issue pertaining whether the arbitral clause itself is valid. This could be whether the contract is valid. So therefore, and assuming for a moment that the contract you say is invalid, then the doctrine of severability says the arbitral clause can be severed from the main agreement, and that is saved. So these are two concepts which have come into the 1996 Act thanks to incidental. Now, incidental law was a body appointed by the United Nations. It consisted of eminent experts in the field of arbitration. And the incidental code was drawn up for international arbitration. It was not drawn up for domestic arbitrations. But we in India adopted it also for domestic arbitration with some modifications, which resulted also in some practical difficulties in the working of the Act. So the first step, when both parties agree, there is no difficulty, the tribunal has full jurisdiction. Then comes the second aspect. What happens when one of the parties refuses to nominate the arbitrator or agree to the appointment of sole arbitrator? The law was Section 11. The matter must go to the under the Act, designated judge under the Act as it then stood. Now, what did the designated judge do? I was handling arbitration in Bombay High Court from 1998 to 2001, if I am not mistaken. I used to spend only half a day of Friday afternoon taking up the Section 11 applications and disposing of all those applications within that period of 2 hours. And what was the test? The test was, is there an arbitration clause? The rest of the issues, leave it to the arbitrator to decide, considering the principle of competence, Section 16. Now, this position remained and was affirmed in Rani construction by a Constitutional judgment of 5 judges led by Justice Bharucha, that this exercise of power is not judicial, this exercise of power is administrative. This position held the field until one bright morning, when 7 judges of the Supreme Court said we must relook into this judgment. And we had Patel Engineering. Now, what did Patel Engineering do? Patel Engineering rewrote Section 11. First, they said that this exercise of power is judicial. Then they created hierarchical jurisdictions which were not there in the Act. So, Patel Engineering brought in the new concept from administrative to judicial. Now, if it is judicial, the question arose, what issues can be decided by the designate? Now, Justice Ravindran in Bogara Polyfabs laid down some tests. Test 1, what can be done by the designated judge? Have you come to the proper court? Is there an arbitral clause? Test 2, issue of limitation, is it stale? Should it be decided by the designated judge or should it be decided by somebody else? Test 3, matters of merit, other issues, all to be decided by the arbitral tribunal. Then the issues came as to what are arbitrable issues. Now, this is a very important aspect in the law of arbitration. And we had a judgment in Booz-Hamilton, not the Booz which you are thinking about, but the name is Booz-Hamilton. In Booz-Hamilton, the Supreme Court, again, if I am not mistaken, Justice Ravindran, laid down the test of what are arbitrable disputes, or rather, what are non-arbitrable disputes. Now, non-arbitral disputes are one disputes which are not under the terms of the contract, falling beyond the terms of the contract. Non-arbitral disputes are disputes which a civil court could not have decided and have to be decided by a special law. For example, take a rent law or a labor law. Now, these are to be decided in special fora, special tribunals. So, these are issues which the Supreme Court said cannot be decided by the tribunal, but will have to be left to the judgment of the respective tribunals. So, these are what are now known as non-arbitrable issues. Now, all these issues would not have come if in Patel Engineers, the Supreme Court had not taken the view that this is a judicial function. If it was an administrative function, it would have been left for decision of the arbitrator himself. Then in 2015, Parliament acted. Parliament acted and said brought in section 11(6)(a) and said what the court is going to decide is only about the existence of the arbitral clause. Okay, you can't go into any other issue. Look at it, prima facie, is there an arbitral clause in existence? And then refer the matter to the tribunal which will decide all issues. Similarly came section 8. In section 8, Sukanya, I had passed a judgment in the Bombay High Court as to when can a party be referred to arbitration when there is an arbitral clause. The test, as per the section which I had then considered, was 1. All parties must be parties to the arbitration. 2. The subject matter of the arbitration must fall within the scope of the arbitral clause. If these two factors are satisfied, then only can you refer the parties to arbitration. If there are third parties against whom you are claiming relief, then you cannot claim. That was upheld by the Supreme Court. Until I will come to the now group of companies doctrine, which I will deal with separately. So that was, Sukanya said that section 8, these are the tests to be applied, and this is what you will do. The next, but after 2015, we have a classic case which bears the name of my colleague, Vijay Dholia, in 2021. Now, 2021 is a judgment which came before the Supreme Court on a reference in another matter, Himantarai, or one of the judgments. And the issue there was a division bench of the Supreme Court had took a view that even in matters under the Transfer of Property Act, not covered by the Rent Act. Now, Transfer of Property Act are matters which can be decided only by the civil court, not by a special forum, not by a special court. And that particular subject matter was not covered by a special court. But yet, the Supreme Court took a view that this is non-arbitrable. Now, this is what came in issue before the Supreme Court in Vijay in that judgment. Now, while answering this reference, we have two judgments, one authored by Justice Khanna and one authored by Justice Ramanna. Now, they have gone into various issues, referred to every judgment, noted amendment, 2015 amendment, noted Justice Joseph's judgment that under Section 11 what you can decide is only existence of an arbitration clause, but went on to affirm Bogara polyfabs. Now, Bogara polyfabs, by the virtue of the fact of the amendment to Section 11, 6A, was no longer good law, because the court could no longer look into other issues except the existence of the arbitral clause. And to the students, because what happens in our country is, unfortunately, judgments are not subject to scrutiny. No, nobody writes critical comments as to why the judgment is wrong. Neither do our judges sitting in the Supreme Court when their colleagues sitting in the Supreme Court correct it. They start doing it only after he has retired. I do not know why. But this is unfortunately the reality of the day. Now the author of Supreme Court cases, para 138 Supreme Court case, if you note, has put an edit that Section 250, that this position is no longer, that's under 2015 Act, Section 8 has been amended. Now Justice Ramanna reads that judgment, says, I have had the benefit of reading the other judgment, takes note of the amendment to Section 215, but either does not tell his brother colleagues that this is not the proper position, and passes his judgment, but noting the amendment to Section 215. Now, what happens to courts, subordinate courts? What happens to arbitrators who are bound by the judgment of Article 141? Now, an arbitrator must have courage to say, this is per incurium. A high court judge may not have that courage to say that this is per incurium, because whatever it is. But this is the unfortunate situation. Today, and believe me, after noting Justice Joseph's judgment that by virtue of the 2015 amendment, Section 8 has been amended, and it is no other question is open except existence of an arbitration clause. That is one aspect. Then we come to the issue of fraud. Now, under the 1940 Act, in just Mr. Oak's judgment, I won't give the citation, there was a theory followed by other jurisdictions also that issues of fraud can't be decided by the arbitrator, can only be decided by the civil court. Now, to those of you in the audience, I would like to pose a simple question. In the field of contract, we have voidable contracts. Voidable contracts are coercion, undue influence, misrepresentation, and fraud. These are not void contracts. These are voidable contracts. A party may choose to go with the contract in spite of this. A party may choose to elect that I am electing to say that this contract is void because it was procured by undue influence, fraud, etc., whatever it is. Now, in all these matters, evidence has to be led as to fraud. Then please enlighten me as to why among the species of contracts of misrepresentation, undue influence, coercion, why is fraud a separate class by itself? Why can't it be treated in the same class as other classes of contract which are voidable? Secondly, if the tribunal, when both parties go before it, can decide the issue under Section 16, why not leave it to the tribunal to decide? So that was 1940 Act, because The 40 Act had a slightly different language. The court may. That was the language of the 1940 Act. The language of the 1996 Act was, Section 8, the court shall. So the difference in terminology. But in Radhakrishna versus Maestro, this concept of fraud cannot be the subject matter of arbitration was brought in. And it continued to hold the field for 15 years and continues to hold the field, I will discuss with subsequently also. Until in the judgment, in this last judgment which I have referred to, the Supreme Court now has overruled this judgment. Vidya Drola. They said this judgment no longer stands. But after having said so, they still hold that serious cases of fraud cannot be decided by the arbitral tribunal. Now I pause over here. After Radhakrishna versus Maestro, the next judgment that came was Ayaswamy. Ayaswamy, there were two judgments, one by Dr. Sikri, one by Justice Chandrachud, the present Chief Justice of India. Now, Justice Chandrachud notes that in areas where our law is not known, we follow English principles. In England, for some time, fraud to the extent of the arbitral clause was held to be non-arbitrable, but then that fig leaf was removed, and that principle was also given up in Fiona Trust. Justice Chandrachud points that out. Follows says that this is what should be the position, but then says, I concur with the views taken by Justice Sikri, Dr. Sikri. After that came a third judgment, following the same principle, and then Justice Nariman in Avitel takes the same view. Now, Avitel came from an award from Singapore, to which I was one of the arbitrators. It was a case where a party entered in the contract, told HSBC that they have a contract with BBC to convert their old films into modern, a huge multi-million-dollar contract. But in fact, there was no contract. So these were but who decided? It was decided by the arbitral tribunal. It was not decided by the court. So therefore, my thought process is, why leave this last fig still saying that matters can still go to arbitration? They cannot go to arbitration, and that is not arbitrable. So these are areas, and what happens is, none of the lawyers practicing in the Supreme Court, they will argue. But when it comes to a critical comment, will not say so. Justice Ramanna in Vidya's judgment notes Mr. Fali Nariman's comments that arbitration in India has grown not because of the judges but without it. These are his starting points in his concurring opinion, which he has so stated. So we are left at the threshold where some doctrines, which are impediments in the arbitral process, I call it impediments. Why call it impediments? Because the arbitral process must be free from court control. Courts must, as the Unilateral Act had done, limited court control in areas where support of the court is required for the purpose of allowing the arbitration to proceed forward. So therefore, this is one area which I thought in my speech I would pose to you all, But to the students and lawyers, what I say is not the law. What the law is, what Ayaswamy Avitel says, that is the law declared by the Supreme Court. There are areas where serious issues of fraud cannot be gone into, or non-arbitrable cannot be gone into by the arbitral tribunal. Having said that, we now come, who can be added as parties? Now the classic case, now Section 2A says party means parties to an arbitral clause. Section 7 says there must be an arbitration agreement in writing, not necessarily signed by both the parties, but could be through an exchange of letters, documents. That will constitute an arbitral agreement. This was the position. Until one fine day came chlorocontrols. Chlorocontrol was a reference under Section 45 where it was an arbitral clause with respect of a foreign arbitration. Now, foreign arbitration, basically what it means is that one of the parties must be a non-Indian. So one of the parties is non-Indian, that removes it from domestic arbitration, takes it to a foreign arbitration. Now there, in Section 45, there is the wording claiming through him or through him. Now the ordinary reading of it any day would be a successor in interest, an assignee, subrogation. These are all issues which will fall within this clause. But the Supreme Court said no. In case of companies, myriad of companies, even if that company is not a signatory to the arbitral clause, then in that event, you can rope him in and bind him to the arbitration agreement. Now in Cox and Kings versus SPA, the Supreme Court has revisited chlorocontrols. They visited chlorocontrols and said that, fine, what chlorocontrol has said is not correct. It does not fall within these words because these are words for derivative action. Derivative action means action by the third parties who step into the shoes of the original signatory to the agreement. But even though they are not parties, and secondly, they recognize that companies are independent bodies. A shareholder is distinct from a company. Theory of control is irrelevant, but then some other tests are laid. But they say, yes, the group of doctrine theory can be rooted into Section 2H party and Section 7. Now that is the law declared by the Supreme Court, which is binding. But what I am aggrieved by the fact is, they have not stopped down there. I will point out to you the last, there are various findings. I will tell you the last finding, which really disturbs me and should disturb you all also, is this finding. In para 172, M. 172M says, in the course of this judgment, any authoritative determination given by this court pertaining to a group of companies' doctrine should not be interpreted to exclude the application of other doctrines and principles for binding non-signatories to the arbitration agreement. Now a whole Pandora's box is opened and lawyers now can laugh because they will be going to the banks. A whole Pandora's box. In which other situations are you going to rope in third parties under the group of companies doctrine? If you had got a group of companies doctrine and stopped down there, I could understand that this much is certain. The arbitral law is certain now in certain situations. Group company can be brought in, though not a signatory, in the arbitral clause. But now a big window is thrown open. Give it to the fertile imagination of lawyers to rope in somebody, drag on the matter for another 10 years by the time the matter goes to the Supreme Court. But the Dharmadhikari was quite, I would say, saying some 10 years. Believe me, it is not 10 years. But the time the matter goes to Supreme Court, and normally it takes you about 20 years. So therefore, now the entire issue is thrown open. Now, is arbitration going to be certain, or is it going to be uncertain? And with this paragraph, this proposition of para 178M, the students behind me, the students who are sitting down, start thinking, we are going to be lawyers. How will you rope in others and the group of the company's doctrine to bind a non-signatory? Now, arbitration is consensual. The basic concept of arbitration is consensual. Two parties agree we will not go to the courts, but instead approach the arbitral tribunal. Now, if there are third parties, nobody prevents them from going to the courts. And what happens in a case? Now, Section 11, when matter comes before Section 11, the court has held, yes, well, leave it to the tribunal to decide. Now, what happens in Section 8? Section 8, a plaintiff comes, claims relief against various persons. Now, is the defendant going to say, now, no, now party 2 and 3 or some other parties don't grant relief against me, grant relief against them and join them to the arbitration? I tell you, it's a mind-boggling concept which has been thrown open, which to what extent it is going to be answered here and after, I do not know. So having said that, then we come to a very important aspect of arbitration law. Now, Section 25(1)(c) confers power on the arbitral tribunal to terminate proceedings if a claim petition is not filed within the time contemplated by the tribunal. Now, such a matter came up before me. I examined the entire Act and found there are two different concepts on the Arbitration Act. There is an award and there are orders. Award is preliminary or final, but a final determination of an issue in the matter. Orders are interim orders, granting interim relief or some discovery, etc., orders which are passed. So I took a view, after spending a lot of time, that now since the concept of ADR has developed, Section 89 recognizes arbitration to be an alternative form of dispute resolution. Since the contempt of court jurisdiction is also applicable in arbitral proceedings, therefore it has the element of court trappings. Therefore it is a public body, a group of persons who are discharging public functions, and therefore Article 226 would apply. I took that view because I found no other way of a gross case of injustice to grant relief to the party, because the Act does not contain any power. Section 5 says of the Arbitration Act, the court shall not intervene unless it is so provided. Unfortunately, Justice Hegde in one judgment said even the revision power is to be exercised. This is by way of aside. Now the matter stood, some other matter came before the Supreme Court. And what does the Supreme Court say? Order 9 will be attracted. Now to those students of law in this audience, lawyers, may I pose a simple question. When does Order 9 apply? Order 9 applies when a suit is filed, when the claim statement is already there. It's only subsequent thereto does Order 9 apply. Now here we are at the threshold of a case where no claim statement is filed. So how will Order 9 apply? It's a food for thought for our students to deliberate. So this is sometimes what happens in the process of trying to seal the matter or close the matter, find something. Then another aspect of arbitration in India, which very few do, is discovery of documents. Now in the field of commercial arbitration, discovery is a very important part. Why is it important? It helps in reducing oral evidence. It helps in finding out what the other party is doing, how it is computing. But this particular area I do not find, I've done so many arbitrations, the discovery aspect is not much, in the sense, lawyers seem either to have forgotten that there is such a concept of discovery under our law. Now there is a judgment also when discovery can be made. Seth's judgment is an old judgment on the law of discovery. Now having said this part of it, now I go to the most important part, which will concern lawyers, students, arbitrators. The law of damages. Now the law of damages are contained in section 73, 74 and 75. These are the three trinity of the clauses where damages can be. Section 73 is reasonable damages if a party proves that it has suffered a loss. Section 74 is the issue of what is called the LD clause, liquidated damages. Now in England, liquidated damages and penalty are two different aspects. In India, our courts have taken the view that whether liquidated damages or penalty, you must prove damages. Now this was except in the class of cases where it is not possible to prove damages. A large number of judgments right before independence, 1939 and onwards, Maula Bucks, Fateh Chand, these are all classic judgments which had taken the view. Then came ONGC versus saw pipes. Now ONGC saw pipes read those judgments, no difficulty. But then put as a general proposition, that is where my thought process is, that when there is a clause for liquidated damages, then the claimant has not to prove anything. It is for the respondent to prove otherwise. Now, at the threshold, for me, this was contrary to the Maulabak Fateh Chand, which are the larger bench judgments. Now, this in Delhi Development Authority judgment, Justice Nariman brought it back on trail. Now, for liquidated damages, what must you prove? One, that in fact that you have suffered a loss. It is not that if no loss is suffered, you can award damages. Two, what is to be awarded is reasonable damages. The sum named by way of LD is the maximum that can be granted. But what the tribunal will grant is the reasonable what has been proved. And three, in a class of cases where it is not possible to prove, for example, the government construct a road. Now, it is not possible to prove how much will be lost by non-use of the road. A bridge. Now, these are cases where, or some other aspects in governmental contracts, where it is not possible to prove damages, then in that event, the LD clause will apply. So that distinction has now been made. So therefore, the law of liquidated, but there are still two lines of thought, as I said over here. Maula Bugs Fateh Chand, DDA, and after ONGC, there are other judgments which have telecommunications, etc., BSNL, which have taken the other view, but those views are restricted to governmental contracts or the nature of governmental contracts where it is not possible. So this is the law insofar as liquidated damages are concerned. But a very important aspect of liquidated damages, which through my 11 years of arbitration nobody argued except in the last international arbitration, was that liquidated damages cannot be awarded if the employer is in default. The contractor may be in default, but the test is, did the acts of the employer result also in delaying the contract? If the acts of the employer also result in delaying the contract, then the LD clause cannot be made applicable. Then in such a case, you have to prove damages under Section 73. Now, for benefit of everybody, I will just refer to the judgments as they are of importance to everybody practicing and non-practicing, because to me also this was a new line of, for the first time, somebody brought it into my attention, which otherwise I was not aware. Now the first judgment which is on this aspect, and this law has been followed by the Supreme Court. The first judgment is Holm versus Guppy. It's an old judgment, 1838, 3 MNW 387. The next judgment is Dodd versus Churton, 1897, 1 QB 5621. And then there is a subsequent judgment of the English courts, which has taken a slightly further multiplex constructions, which I have referred to. But our Supreme Court has, in just one moment, accepted the judgment in Churton, which is that, just a moment, I can't find my note. Yes. In Welspun Specialty Solution Limited versus ONGC, 2022, 2 SEC 382. And this is what the Supreme Court has now said. In order to consider the relevancy of time-conditioned obligations, we may observe some basic principles. Subject to the nature of the contract, general rule is that promisor is bound to complete the obligation by the date for completion stated in the contract. This is a general rule. B, that is subject to the exception that a promisee is not entitled to liquidated damages if by his act or omissions he has prevented the promisor from completing the work by the completion date, following Holm versus Gulpy. These general principles may be amended by the express terms of contract as stipulated in this case. Therefore, the law is that merely because there is a liquidated clause for damages and the contractor is delayed, is no answer to grant him compensation. You have to also apply the test. Did the employer was also a party in causing this delay? Section 54 of the Contract Act speaks about reciprocal obligations. So therefore, this is the law insofar as liquidated damages are concerned. Then the next aspect of the liquidated damages is, many a time, people borrow monies from banks for the purpose of the contract. In such cases, can you award damages to such a person for this additional expenses that he had to undergo because delay occasioned by the acts of the employer and he had to borrow fresh capital? Now, there's a direct English authority for this proposition. Just one moment. That is in the case of FG Minter Limited versus Vaish Health, 1981 WL 186912. If interest is charged on account of default, can that be supported? There's an old English authority, there's old authority of the Allahabad High Court which says that this is penalty. And once it is penalty, you have to prove reasonable damages. Otherwise, merely because the clause is there, you will not be awarded damages. You will not be awarded the penalty amount. And ultimately, what is the test of penalty? The test of penalty is if the contractor is entitled to X amount and there's a penal clause which reduces that amount by X, A and B, that would be by way of penalty. And in this case of by way of penalty, of course, the employer can claim penalty, but he'll have to prove the damages that he has to suffer, and he'll be entitled to reasonable compensation. Then having come to this, then the last of the issues are on interest. Now the old law was that now section 31(7) provides for under what circumstances interest can be awarded. Parties can agree that by a term of the contract, that even if the employer is in breach of the contract, then for pre-referral period, up to the time of the award, no interest will be granted. Such a clause has been upheld by the Supreme Court. So therefore, a clause can be inbuilt into the contract to avoid the interest for this period. Then the next question is whether on the principal and interest is awarded up to the date of the award, can that be the subject matter of further interest on the principal, on the interest component, or what we call compounding interest? The law is settled. Justice Bobde was the leading judgment in that matter, that yes, interest can be awarded on the principal cum interest which was awarded. So therefore, this is a glimpse of the arbitral law as it stands in India today. I have tried to be in, and lastly, without the issue of fraud, not issue of fraud, issue of what is public policy. Now, public policy in section 34 was one of the grounds for a challenge. What is public policy? Students of law, it's an unruly horse from which the rider cannot dismount. One does not know where it will take him. These are the classic cases of when you start reading public policy. In international law, the New York Convention has defined what are the concepts of public policy. And those are the narrow concepts which were accepted by the Supreme Court in Renu Sagar. The question was, what would be the concept of public policy under domestic law concerning section 34? There again, somehow or the other, I was the first to have a look at it in the Bombay High Court. I think a matter of ONGC or somebody. And to me, I did a lot of research. It took me a lot of time. I took it to this test that if there's an error of law apparent on the face of the record, why should not that be used as a concept for interfering with the award? Take an illustration. The award says you must follow the laws of India. The arbitrator does not follow the laws of India. Now, under section 34, the challenge in such a matter is only was public policy. Therefore, unless public policy was roped into this aspect, the arbitrator sees it that he has not followed the law, But what is the ground to set aside that award? It could only be public policy. ONGC slightly took, again, ONGC took a slightly, but now the law has been amended correctly to say, Section 34(2)A has come in. Grounds of public policy also have been defined under Section 34. So at least now to some extent, in the area of public policy, there is certainty that these are the grounds on which you can, fundamental policy of Indian law is one of the grounds which can be looked into. And then 2A, which says is not in accord with the law of India. So there are so many other things to be said, but I think it's also time for something to bite also. So with these few words, I must thank the organizers, and especially Mr. Avinash Pense, to my colleagues over here who have encouraged me to speak. And I am always fortified when I come before young students. I don't know why. Because I always say they are the future of our institutions. Unless you have young students, dynamic students, who have that bearing, who participate in conferences, seminars, that enlightens you. You may not get everything that you want. And you may also say, what is this fool talking? That is also possible. But believe me, every fool has got something. I'll give you a classic illustration. There was this family of 3 lawyers, grandfather, father, and son. They were conducting a matter. And one evening, the grandson comes to the table and tells the grandfather and father, what were you doing in this matter? The matter was entrusted to him for his. So I have looked up the matter. There was nothing in it. And the judge has dismissed it. The grandfather looks at the grandson. So the grandson, you know this house which you are staying, the grand mansion, that is built from the billing in that matter. The father says, son, do you know the cars, all these Mercs and which are there? They are from that matter. And what have you done? So sometimes listen to old people also. Thank you so much.
Silence, please. Please keep quiet. Thank you, Honorable Shri Justice Ribelo, sir, for that thought-provoking presentation and being brutally honest in most of the matters. Thank you so much. Well, there are students, there are those who are participating in this seminar. There could be lots of questions in your heads. Now, here is your chance to quiz the judges. So, there would be an order. You raise your hand for asking a question. The mic will be given to you. Rise at your own place. Tell your name. Tell the question and tell who should answer this question. And there is one more request. There won't be any supplementary question again. You will be given chance only once. Your time starts now. Please raise your hand, those who want to raise a question. Mic there. Your name, sir, question, and to be answered by the faculty.
Hello, sir, I am Gondani. I am retired chief engineer of CPWD and a practicing valuer also. I have a question on mediation. Sir, I will just read section 27(1), which deals with, when the mediated settlement agreement is there and it is signed by both the parties under the overall authentication of the mediator. And then it becomes, binding to both the parties. Now, I have a question. What happens if one or both the parties refuse to sign? And if they are not satisfied with the agreement? Because once the agreement is done by the mediator, both the parties will read, then only they will sign. Now, if one of the parties even refuses to sign, what a mediator is supposed to do then? This is one question.
He has to submit a failure report.
Okay.
That is the next section.
Okay.
Because this is totally voluntary process. Nobody can be compelled, forced. So even if at that stage one party refuses to sign, mediation has failed, mediator will submit a failure report. He cannot assign any reasons. He cannot comment on conduct of parties. It is only simply one-line report, mediation failed.
But nothing is said about this, sir, in the Act. What is to be done? There is a big question mark.
Look at the next section which speaks of failure report, submission of...
Okay.
There it is prescribed.
Sir, my second question is...
Sir, there are young students.
Okay,
you can interact with the faculties later on. We would like to give chance to the young students, those who would have had any questions to be asked to the faculties. You can interact with the faculties later on as well. Any questions from the students? Your name, please, question, and to be answered by which faculty?
Good afternoon, sir. Sir, my name is Aman Ali. I'm 8th semester student. So my question is that to Justice Rebello, sir, is that you actually said one of the merits of arbitration that it maintains confidentiality, which is not observed in civil courts. Sir, but don't you think that when such matters, when they go for appeal, their confidentiality can be compromised? And so with respect to confidentiality, why can't they be observed in civil courts?
Hello, you are right. The law evolved is between the parties. Within that fora, it remains secret, subject to an exception if it comes in appeal. But insofar as courts are concerned, they are an open forum. Courts are an open forum except in those cases where the court will say, for example, in some rape case, some person deposing, the court may say we will not allow other persons except lawyers, perhaps others not to be present. So the basic test is courts are open forums to which all citizens are entitled to come in and watch the proceedings and can't participate, of course, watch the proceedings. So these are the basic tests between confidentiality of a tribunal and openness of the civil court.
Thank you, sir.
Students, don't go back to your home with a question in your mind. Here is an opportunity. Ask a question to these respected judges, and your queries and your wisdom would get enriched. Please feel free. Let it be a stupid question, it doesn't matter. Mike.
Sir, my question is...
your good name, please.
Myself, Kaustu Kupulwar. I am 4th semester student, 3-year law. You have mentioned the case Booz-Hamilton, in which you have said test of what are arbitrable disputes. Maybe there is a continuous evaluation of what can be considered as arbitrable disputes. Can you throw some light upon it?
Kindly read Vidya judgment, Vidya Dwara judgment. If you read that judgment,
Yes.
it's 2021 Supreme Court cases. You'll find the exposition of law. You read 2 judgments. You read Hamilton. See, basically, what a non-arbitral dispute, as I said earlier, was 1, matters which can be decided by special forums. The law says the law creates a special forum to decide those disputes. The power of an arbitrator is coextensive with the power of a civil court. So the civil court can't decide that, neither can the arbitrator decide that. Secondly, in the Vidya judgment, they have gone slightly further. They have tried to expand within rem and personam. Now the doctrine of rem is attached to the subject matter. Now, this doctrine normally comes in administrative jurisdiction, for example. When the ship is arrested, you will not, those of practicing in the coastlines, we have what is called administrative actions, where for the dues, certain dues, the ship can be attached. That is an action in rem. But when the ship owner or the insurer comes in, it gets converted into action in personam. So these are the small distinctions, but it's a large subject for the purposes. But basically, non-arbitrary disputes are disputes which have to be decided by special forums and which cannot be decided by, what cannot be decided by a civil court also cannot be decided by the tribunal.
Thank you, sir.
Sir, my name is Aishwarya Lakde. I am from fourth semester of the 3 years LLB. Sir, what qualities and skills to be developed by law student to become an arbitrator or mediator?
Whom do you want that question to be answered?
What skills are required? First and foremost, the first skill that is required is you are updated in your law. That's the first basic question. Do you know your law? 2, your temperament. How do you approach the matter? How will you do between the matters? Now it's all for students to become arbitrators. You are still, it requires years of experience to be an arbitrator. It is not something like when we have young judges coming in, they are not immediately asked to preside on matters. We give them training for at least a year or 2 years to know all the nuances. And then only do they sit in courts to decide matters. So your time will come, but first thing first, learn your law. That is the most prerequisite of an arbitrator. Mediator is, my brother Justice Dharmadik will answer, but it requires a great deal of patience and knowing how to bring the parties together.
Many things come only by experience. As you grow, means like your mustache or beard, this qualification will also come to you. Don't worry.
Thank you, sir.
Okay.
Sir, if any case is dismissed in any court, actually judgment is done. But why the court given chance for appeal? Because nowadays what happening, time consuming is also. That's why I'm asking these questions. If any case,
No, but that, see, ultimately, there is something called checks and balances. If the trial court had full knowledge and could decide without committing any errors, then that would be the end of the trial. But practical experience shows that the trial court commits errors. So there's a higher court to see if the court has committed errors, and if it had committed errors, to bring that, to correct that error. And then we have still the high court. We have the forum of trial courts, district court, which is the first appellate court, the high court, which is the second appellate court otherwise, and then we have the Supreme Court.
yes.
And after that, we have only God.
Yes. Thank you. Thank you, sir.
Well, no girl has asked a question yet. I would request girls to be at par with boys. Get represented, gender neutrality. Any more questions from the house? Well, with no more questions, I request Dr. Ravi Shankar Moore, Principal RTMNU, Dr. Babasaheb Ambedkar College of Law, to propose formal vote of thanks.
Good afternoon, everybody. Honorable Dias, on behalf of ADR Professional Association, High Court Bar Association, and our own Dr. Babasaheb Ambedkar College of Law, I am here to propose the formal vote of thanks. First of all, I extend my heartfelt gratitude to each and every one present or here who has participated and contributed to this symposium. We are immensely grateful to our esteemed speakers, Honorable Sri Justice Ferdinand Rebello and Honorable Sri Justice B.P. Dharmadhikari sir, for sharing their invaluable insight and expertise in reaching our understanding of arbitration and mediation. Sirs, your passion and dedication have truly inspired us all. A special thanks to Honorable Sri Justice Vijay Daga sir, who remained present and participated in this symposium. Special thanks goes to all the attendees for your active engagement and thoughtful discussion throughout the event. Your enthusiasm and diverse perspectives have made this symposium a truly enriching experience. We would also like to express our gratitude to the sponsors and the partners, office bearers of High Court Bar Association, Vice President of High Court Bar Association, Advocate Sharad Bhattarji, office bearers of ADR Professional Association, MD Sri Avinash Pense sir, Advocate Sri Kaleji, Master of Ceremony MOC Sri Prasanna Kulkarni ji, teaching faculty members of this college, members of the High Court Bar Association, and many other professional associations. They have came to participate in this symposium. We thank each one of you for your generous support, without which this event would not have been a possibility. Last but not the least, a big thank you to the organizing team, the faculty, students, and other participating organizers for their hard work and dedication in planning and execution of this symposium seamlessly. As we conclude this symposium, let us carry forward the knowledge and connections we gained here to continue advancing our field and advancing our knowledge in the field and making a positive impact in our communities. Thank you once again to everyone involved.
Sir, thank you, sir. I request you all to please rise for national anthem.
जनगण अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Dear participants, snacks and high tea has already been arranged for all the participants. So please help yourself.
बिलकुल मला ॲड्रेस पाठवा, नंबर पाठवा, मी लगेच पोहोचतो.